In the winter of 1857, the President-elect of the United States secretly colluded with members of the Supreme Court to fix the outcome of a pending case.
Which is just staggering when you think about it.
Right. It was a backroom shadow broker deal designed to permanently settle a massive national crisis and, well, theoretically prevent a civil war. But instead, this coordinated effort became the spark that killed 750,000 Americans.
Yeah, it remains one of the most chilling examples in our history of what happens when the supposed neutral umpires of our constitutional system decide to take off their masks, put on team jerseys, and rewrite the rule book to achieve a desired political outcome.
Welcome to today's deep dive. We are taking a grave, measured, and, documentary-style look into a massive stack of sources today. It's a historical dossier on the 1857 Supreme Court decision, Dred Scott v. Sandford.
And it is a heavy topic.
It really is. Our mission today is to thoroughly unpack this pivotal moment in American history. We're not just looking at a legal footnote you might dimly recall from high school civics. As you'll see, we are going to explore a profound human tragedy that completely fractured and reshaped the nation.
Which brings us to the overarching theme of our discussion today. The central question you have to grapple with as we go through this material is this: is the Supreme Court truly above politics, operating as a purely rational, insulated legal entity? Or is it fundamentally a human institution, deeply shaped by the passions, the prejudices, and the intense political pressures of its era?
Okay, let's unpack this, because if we want to actually answer that question, we cannot start with abstract constitutional theories.
No, you really can't.
The history books have a terrible habit of treating Dred Scott as just a case name, a shorthand for a constitutional crisis.
Yeah.
But the sources we're looking at today insist that we ground this in reality. Before this was a Supreme Court crisis, it was a story about a very real family fighting for their absolute survival.
Right. To understand the terrifying gravity of the legal decisions made later, you have to understand the human beings at the center.
Exactly. Who were they?
Well, Dred Scott was born into slavery in Virginia around 1799. And by the 1830s, he had been purchased by an army surgeon named Dr. John Emerson.
An army surgeon, so he's moving around a lot.
Yeah, precisely. Because Emerson was a military officer, his postings required him to move across the country.
And this movement is the engine of the entire legal battle, isn't it? They didn't just stay on a plantation in the Deep South.
No, they didn't.
Emerson took Dred Scott from Missouri, which was a slave state, into Illinois, which was a free state. And then, crucially, he took him to Fort Snelling. What exactly was Fort Snelling, and why is that specific location legally explosive?
So Fort Snelling was a military outpost located in the Wisconsin Territory. That's what is today the state of Minnesota.
Okay.
And it was situated on free federal territory. Under the Missouri Compromise of 1812, slavery was explicitly federally banned in that specific region.
Wow. So we have an enslaved man being transported by his enslaver to live and work on a federal military base where slavery is, by the laws of the United States Congress, entirely illegal.
Right. It's a massive contradiction.
It really is. But the dossier brings up a critical detail that gets constantly overlooked in this narrative. Dred was not suing alone.
No, he wasn't.
This wasn't just one man's solitary individual quest for freedom. His wife, Harriet Robinson Scott, was a co-plaintiff with a parallel claim.
And Harriet's involvement changes the entire stakes of the case. I mean, they actually met and married while they were both living at Fort Snelling.
Really?
Yeah. She was also enslaved, originally held by a different military officer, Lawrence Taliaferro, before her ownership was essentially transferred to Dr. Emerson so the couple could be together.
I see.
So by filing a parallel claim years later, she was asserting her own independent right to freedom based on her residence in that exact same free territory.
I was looking at this detail about their daughters, Eliza and Lizzie, and just the massive burden this couple was carrying. The sources emphasized that this couple's suit was really about securing the future for these two young girls.
Absolutely.
Can you walk us through the actual legal mechanics of why Harriet's parallel suit was so vital to their daughter's survival?
It comes down to a brutal legal doctrine that governed the institution of slavery, known as partus sequitur ventrum.
Partus sequitur ventrum.
Right. Under this law, a child's legal status, whether they were born free or enslaved, followed the status of the mother, not the father.
Which is incredibly dark when you realize that it was designed as an economic engine to protect enslavers, ensuring that any children born to enslaved women, regardless of who the father was, automatically became property.
That is the grim reality of it, yeah. So legally speaking, if Dred Scott somehow won his freedom, that victory would not automatically free his daughters.
Oh, wow. So they would remain enslaved.
Yes, they would remain enslaved. But if Harriet could prove that she was legally free because of her time at Fort Snelling, then by law, her daughters, Eliza and Lizzie, would also be legally recognized as free people.
It's like they were forced into this terrifying, impossibly high-stakes gamble.
It really was a gamble.
They are throwing themselves with zero resources against a massive, brutally indifferent legal machine, risking absolutely everything just to ensure their children wouldn't be treated as livestock. What happens to them if they lose?
Well, if they lose, they face the very real, immediate threat of retaliation. They could be sold down the river, literally, to the brutal sugar or cotton plantations of the Deep South.
Oh, God.
They would almost certainly be separated from each other and separated from their girls. I mean, the punishment for challenging their enslaver in a public court and losing could be catastrophic.
Which brings up a logistical nightmare. Legal fights take years. They require lawyers, court fees, endless filings. How does an enslaved family in the 1840s, who legally cannot own property or earn wages, manage to sustain a lawsuit that eventually reaches the highest court in the land?
This is one of the most complex, psychologically fascinating layers of the dossier. The funding came largely from the Blow family.
The Blow family.
Yeah, they were a wealthy, prominent family in St. Louis, and they were actually the descendants of Peter Blow, who was Dred Scott's original owner back in Virginia.
Wait, I need to make sure I understand this. The descendants of the man who originally enslaved Dred Scott are the ones paying the legal bills to help him sue a different enslaver for his freedom.
That is exactly what happened.
That's wild.
It is. The Blow family had become sympathetic to the Scots' plight. It really highlights the deeply complex, contradictory, and almost surreal personal relationships that could exist within the oppressive framework of slavery. They provided financial support, they hired lawyers, they paid the necessary court bonds.
It's a stark reminder that history isn't just monolithic blocks of cartoon villains and flawless heroes. It's built on chaotic, individual human choices.
Very true.
But this deeply personal fight for a mother and father trying to protect their daughters quickly gets swallowed by this labyrinth of a legal system. So they begin this fight in 1846 in the Missouri state courts. And they actually have a really strong case, right?
Surprisingly strong, yeah.
Yeah.
Their argument was based on a well-established legal precedent in Missouri at the time, which legal historians refer to as the once free, always free precedent.
Right, I read about this. How exactly did that mechanic work in a slave state?
So, Missouri courts had historically recognized that if an enslaver voluntarily took an enslaved person into a free state or territory for an extended period, that person's legal status permanently changed.
You just became free.
They became a free person, and forcibly returning them to Missouri did not re-enslave them.
Why would a staunch slave state like Missouri have a law that liberated enslaved people? That seems so counterintuitive.
It was primarily for geopolitical harmony. Missouri was surrounded by free territories in states like Illinois. To maintain trade and peaceful relations, Missouri courts essentially said, "We will respect your laws regarding freedom if you respect ours regarding slavery."
Oh, I see.
It was a legal courtesy, basically a form of state-level diplomacy. The doctrine meant that residents on free soil extinguished the property right of the enslaver.
So when Dred and Harriet walk into court in 1846, they aren't throwing some wild, unprecedented legal Hail Mary. They are literally just asking the court to follow its own established rules.
Exactly. And initially, the system worked the way it was supposed to. After a few procedural hiccups, a St. Louis Circuit Court held a trial, heard the evidence of their residence at Fort Snelling, and in 1850, a jury actually ruled in favor of the Scots.
Let's just pause on that reality. Imagine the overwhelming relief. For a brief, fleeting window in 1850, Dred, Harriet, Eliza, and Lizzie had won.
They did.
The state of Missouri looked at them and declared them legally free.
It was a monumental victory, but unfortunately, it was incredibly short-lived. The widow of Dr. Emerson, Irene Emerson, who held the legal claim to the Scots, appealed that jury decision to the Missouri Supreme Court.
And this is where the toxic national politics start bleeding into the courtroom. What happens at the Missouri Supreme Court?
Well, in 1852, the Missouri Supreme Court hands down a devastating reversal. They ruled against the Scots, returning the entire family to slavery. But the critical part of this ruling isn't just the outcome, it's the rationale.
Right.
They didn't argue that the lower court misapplied the facts of the case. Instead, the Missouri Supreme Court explicitly and deliberately repudiated its own once free, always free precedent.
Wait, they just throw out decades of their own established law. How did they legally justify that?
By openly admitting they were changing the rules to match the political climate?
Are you serious?
Yeah, the court's opinion basically stated that in a past era of dark and sleepy times, they might have recognized the laws of free states as a courtesy. But by 1852, the national debate over slavery had become incredibly polarized.
So they just got defensive.
Exactly. The court declared that with anti-slavery sentiment growing in the North, Missouri would no longer yield to Northern laws. It was a purely political defensive posture designed to protect the institution of slavery from outside pressure.
The umpires taking off the masks? They aren't even pretending to be objective. They openly stated, we are changing the law because we feel politically threatened.
Exactly.
So if the Missouri Supreme Court shuts the door in their face, how is this not the end of the road? They're enslaved in Missouri. Missouri says, too bad. How does a case like that suddenly leap out of the state system and onto the federal docket?
Through a specific legal mechanism called diversity jurisdiction. By 1854, the ownership of the Scotts had been transferred from Irene Emerson to her brother, a man named John F.A. Sandford.
Ah, Sandford. And I want to note here for anyone looking up the case documents, there is a massive clerical error in the files. A federal clerk misspelled his name as Sandford with an extra D. And because legal records are so rigid, that typo is forever frozen in history as the name of the most infamous case in America.
It's a bizarre historical quirk on a document of profound tragedy. But the key legal point is John Sandford's residency. Sandford lived in New York.
Okay.
Dred Scott, claiming to be a citizen of Missouri, was now suing a citizen of New York.
And when citizens of two different states sue each other, the Constitution allows that case to be heard in a federal court to ensure neither state court is biased against the out-of-stater.
Exactly. So with the help of new lawyers, they filed a brand new federal lawsuit, Scott v. Sandford, in the Federal Circuit Court in Missouri.
And how did that go?
Well, the federal court also ultimately rules against Scott, which sets the stage for the final appeal all the way up to the Supreme Court of the United States in 1857.
Which brings us to a massive structural mystery in this whole saga. When I look at the sources detailing the moment this case landed on the Supreme Court's docket, it is blindingly obvious that the justices had a very simple, well-established, incredibly boring way to make this case disappear. But they deliberately chose to ignore it.
Yeah, it is one of the great what-ifs in American constitutional history. The court absolutely had an off-ramp right in front of them.
Let's explore that off-ramp. Because the dossier reveals that Justice Samuel Nelson had actually drafted an initial opinion that would have decided the case on the most narrow, modest grounds possible. What did Nelson's draft say?
Justice Nelson's draft was a textbook example of judicial restraint. His logic was straightforward. The federal court should generally defer to the highest court of a state when it comes to interpreting state law.
Okay, that makes sense.
So Nelson's draft essentially said, look, the Missouri Supreme Court already decided Scott's status under Missouri law back in 1852. They said he's enslaved, therefore federal hands are tied, we defer to Missouri. Case closed.
Now, obviously, that is still a tragic, horrific outcome for the Scott family. But from a purely institutional standpoint, that easy out keeps the Supreme Court completely insulated from the explosive national debate over slavery in the territories. It's the standard conservative way for a court to handle a politically volatile case.
Precisely. Nelson's draft would have maintained the fragile status quo.
So I have to push back here. If a Supreme Court is supposed to be, as Alexander Hamilton famously called it in the Federalist Papers, the least dangerous branch, a branch that relies entirely on public legitimacy and intentionally avoids stepping on political landmines, why on earth did they reject this narrow path?
It comes down to sheer, unadulterated judicial hubris, driven by the specific composition of the court at that time, and specifically led by Chief Justice Roger B. Taney.
Let's talk about Taney. I was looking into his background, and the contradiction here is maddening. This is a guy from Maryland, appointed by Andrew Jackson. He was a former slaveholder, but he had actually emancipated his own enslaved people decades earlier.
He did, yes.
How does a man who voluntarily freed his own slaves go on to author the most fiercely, aggressively pro-slavery legal opinion in American history?
It is a dark evolution. By 1857, Taney is elderly, frail, and deeply viscerally committed to the Southern way of life.
So he just doubled down over time.
Over the decades, yeah, he had grown fiercely defensive against what he perceived as Northern aggression and moralizing. He viewed the anti-slavery movement not as a moral crusade, but as a political threat designed to destroy the South.
So instead of taking Nelson's narrow off-ramp, Taney and the majority actively choose to reach past the specific facts of this one family's plight. They want to grab the third rail of American politics. Why?
Because they suffered from the delusion that they could save the country by themselves. The political branches, Congress, and the presidency had been tearing themselves apart, bleeding over the issue of slavery's expansion for 40 years.
Right.
Taney and the Southern majority on the court genuinely believed that they could step in, issue a definitive, sweeping, unassailable ruling, and magically settle the national slavery question forever.
It is breathtaking arrogance. To look at a country practically vibrating with violence, literally fracturing in half, and think, don't worry, 9 unelected lawyers in robes are going to write a very stern essay, and everyone will simply go home and quiet down.
It really is. And to achieve that sweeping answer, they had to discard Nelson's narrow ruling and tackle the biggest, most dangerous constitutional questions head-on.
Here's where it gets really interesting and incredibly dark, because the text of Taney's decision is not just a legal document. It is a bombshell. The dossier breaks Taney's majority opinion down into 2 devastating structural holdings that alter the fabric of the country. Let's walk through the mechanics of those holdings.
The first major holding addressed the concept of citizenship and standing. The procedural question was, did Dred Scott, as a black man, even have the right to sue in a federal court in the first place? To access federal courts under diversity jurisdiction, as we discussed, you have to be considered a citizen of a state.
And Taney's conclusion was absolute. He ruled that people of African descent, regardless of whether they were enslaved or if they had been free for generations, were not and could never be citizens of the United States.
It was a total legal erasure of an entire race of people. Taney argued that the founders who wrote the Constitution and the Declaration of Independence never intended for black people to be included in the political community of we the people.
Which brings us to the most infamous, chilling sentence from the entire decision. Taney wrote that at the time of the founding, black people were regarded as, and I am quoting the text directly here, so far inferior that they had no rights which the white man was bound to respect.
It is a devastating line that has echoed through history, and there is a robust historical debate over how to properly interpret those specific words in the context of legal jurisprudence.
I noticed this in the sources. The debate centers on intent. Was Taney stating his own personal horrific conviction in that moment? Or was he attempting what modern lawyers would call an originalist historical analysis of the founders' views?
It's a critical distinction for understanding how legal arguments are constructed. The text of the opinion explicitly frames it as historical analysis.
Okay, so he's trying to sound objective.
Right. Taney is essentially arguing, I am acting as a historian. I am looking back at the colonial laws, the statutes, and the social norms of 1787. And based on how they treated people of African descent back then, it is an undeniable historical fact that the founders viewed them as an inferior class with no rights.
I see.
He claimed he was merely reporting the objective historical reality of the founders' intent, not necessarily imposing his own morality.
But the mechanics of that distinction almost don't matter to the millions of people it impacted. Whether it was driven by his personal virulent racism or driven by a deeply flawed, cherry-picked historical methodology, the legal effect on the ground was identical.
Completely identical.
He used the immense power of the Supreme Court to legally erase millions of free and enslaved black Americans from the national community. He stripped them of any constitutional protection and slammed the federal courthouse doors shut in their faces forever.
Exactly. If he had stopped writing right there, it would already stand as one of the most consequential and tragic decisions in American history.
Wait, if Taney just ruled that Scott wasn't a citizen, and therefore the court had zero jurisdiction to even hear the case, shouldn't the gavel come down right there? Case closed, we have no authority, everyone go home. Why does Taney keep writing?
Procedurally, you are entirely correct. Once a court determines it lacks jurisdiction, it is supposed to stop. Any further commentary is legally weightless.
But he didn't stop.
No, Taney didn't stop. Having slammed the door on Scott, he forged ahead to address the massive political elephant in the room, the Missouri Compromise.
And he didn't just address it, he incinerated it. Taney declared the 1820 Missouri Compromise entirely unconstitutional.
This is the ruling on congressional power. For over 35 years, the Missouri Compromise had been the fragile glue holding the nation together.
The literal line on the map.
Exactly. It drew a literal geographic line across the expanding map. Slavery was allowed below the line and permanently banned above it. But Taney ruled that the United States Congress had absolutely no constitutional authority to prohibit slavery in any of the federal territories.
Let's slow down and break down his legal logic on that, because he uses the Fifth Amendment to do it, which feels completely backwards to a modern reader.
It relies on an early application of a legal concept that would later become known as substantive due process.
Okay.
The Fifth Amendment states that no person shall be deprived of life, liberty, or property without due process of law. Taney's entire argument hinges on the premise that enslaved people were strictly, legally, property, no different than a horse or a wagon.
Let me make sure I understand the mechanics of this.
Yeah.
If we use a modern equivalent, say, I legally buy a car in a state where it's legal, I then drive that car across the border into a federal territory. Taney's saying that if Congress passes a law that says my car is confiscated the moment I cross the border, Congress is depriving me of my property without due process.
That is the exact logical framework Taney applied, except he was applying it to human beings. Taney ruled that an act of Congress that deprives a citizen of his property merely because he brought that property into a particular territory could hardly be dignified with the name of due process of law. Therefore, any federal law banning slavery in the territories was void.
So the federal government could not restrict the expansion of slavery anywhere.
Nowhere.
There's a massive, blinding irony here regarding the concept of judicial review. The sources point out that this was only the second time in the entire history of the United States that the Supreme Court had struck down a federal law.
Yes, the first being Marbury v. Madison in 1803, which is the case that established the power of judicial review in the first place, the power of the court to declare laws unconstitutional.
So we have to stop and highlight this paradox. The Supreme Court utilizes this awesome ultimate power. The very power gave itself to protect the Constitution and defend the liberty of the people. And the very first time they deploy it on a massive national scale, they use it specifically to protect the expansion of human bondage.
It is the ultimate perversion of the mechanism. Judicial review is designed to be a check against the tyranny of the majority to protect fundamental rights.
Right.
Here, Taney weaponizes that exact mechanism to enshrine the tyranny of slavery into the Constitution itself, placing the property rights of enslavers far above the human rights of the enslaved and above the democratic rule of Congress to regulate its own territories.
It's staggering. Taney delivers this sweeping, seemingly definitive decree from the bench. He thinks he's ended the debate forever. But this unanimous-sounding pronouncement from on high was actually fiercely opposed from inside the very same room. The decision was 7-2. And those two dissenting justices did not go quietly.
They absolutely did not. The two dissenters were Associate Justice Benjamin Robbins Curtis, a Whig from Massachusetts, and Associate Justice John McLean from Ohio. Both men wrote incredibly powerful, detailed dissents.
The dossier spends a lot of time on Justice Curtis's dissent, specifically how surgically he dismantled Taney's historical arguments. Taney based his entire citizenship ban on the originalist claim that black people had never been part of we the people at the founding. How did Curtis attack that?
With plain, undeniable, objective historical fact, Curtis used what we might call counter-history.
Okay, what did he find?
He pointed out that at the time the Articles of Confederation were drafted, and when the United States Constitution was ratified in 1787, free black men were legally recognized as citizens and actively exercised the right to vote in at least 5 states: New Hampshire, Massachusetts, New York, New Jersey, and North Carolina.
Wait, so Taney's entire originalist historical narrative, the foundation of his ruling, was just objectively false?
According to the historical record Curtis presented, absolutely. Curtis argued that if free black men were voting on the ratification of the Constitution itself, they were undeniably, legally part of the people who created the nation.
That makes perfect sense.
Right. And if they were citizens at the founding, the Supreme Court had zero constitutional power to retroactively strip them and their descendants of that citizenship 70 years later.
It completely vaporizes the foundation of Taney's ruling.
Hmm.
But Curtis didn't stop at the history. He went after the procedural hypocrisy we talked about earlier.
Right. What's fascinating here is how Curtis explicitly called out the majority for judicial overreach. He pointed out the exact contradiction you noticed. If the majority decided the court lacked jurisdiction because Scott wasn't a citizen, their legal authority ended at that exact sentence.
Right. If you don't have the authority to hear the case, you don't have the authority to strike down the Missouri Compromise.
Curtis argued that everything Taney wrote about the territories in the Missouri Compromise was, in legal terms, obiter dictum.
Obiter dictum.
Yeah, it means things said, by the way. It was completely unnecessary to the decision of the case, and therefore it was not legally binding precedent.
He essentially accused the Chief Justice of the United States of writing a partisan political manifesto and disguising it as a binding legal opinion.
That's exactly what he did.
And the personal stakes of this internal conflict were incredibly severe. Justice Curtis was so disgusted, so profoundly estranged from the court after this decision, that he took an unprecedented step.
He resigned from the bench.
Unbelievable.
A sitting Supreme Court justice at the absolute height of his legal career walked away from a lifetime appointment because the institutional rot had become so severe he could no longer participate.
Yeah.
It was a massive, glaring public signal that the Supreme Court had fundamentally broken down.
So you have to ask, how could the majority of these highly educated, experienced jurists completely ignore the basic historical facts Curtis presented? How could they so blatantly overstep their constitutional bounds? That brings us to the shadows behind the bench. The sources reveal the backdoor politics that were actively corrupting the judicial process.
To understand the outcome, you first have to look at the geographic composition of the court at that exact moment. Of the 7 justices in the majority who ruled against Dred Scott, 5 were from slaveholding states in the South.
But wait, isn't that incredibly hypocritical on a philosophical level?
Yeah.
The Southern political bloc usually championed states' rights and local control, but here they are, using the immense power of the federal Supreme Court to force northern free states to accept the expansion of slavery.
It is a glaring hypocrisy, and it proves that their commitment was to the institution of slavery, not to the abstract principle of states' rights.
Right.
They abandoned states' rights the moment federal power could be used to protect their economic interests. But the dossier outlines something even more sinister than just regional bias. It uncovers the active shadow involvement of the President-elect of the United States, James Buchanan.
This is where the myth of the neutral arbiter completely collapses. Buchanan was a Northern Democrat, but he had incredibly strong Southern sympathies. He had just been elected in the fall of 1856.
Right.
And he desperately wanted the radioactive issue of slavery resolved before he took the oath of office, so it wouldn't define and destroy his presidency. So what does he do?
He violates the separation of powers. He secretly begins corresponding with sitting Supreme Court justices while they're actively deliberating the Dred Scott case.
Wow.
Specifically, he wrote to Justice John Catron of Tennessee, asking if the court was going to decide the case before his inauguration, and hinting very strongly that he wanted them to definitively rule on the constitutionality of the Missouri Compromise to settle the issue.
Let's contextualize how insane that is. That's like the commissioner of a sports league texting the head referee during the 4th quarter of the championship game to make sure the fix is in and demanding they throw a very specific flag to permanently alter the outcome of the game.
It is a profound breach of constitutional ethics, and it gets worse.
How does it get worse?
Justice Catron actually wrote back to the president-elect, leaking inside information about the court's internal confidential debates. Catron even asked Buchanan to use his immense political influence to personally pressure another justice, Justice Robert Grier of Pennsylvania, a Northerner, to join the Southern majority.
Oh, my God.
Catron knew that if it was a purely Southern partisan ruling, it would look illegitimate. They needed a Northern name on the opinion.
So the president-elect of the United States is actively whipping votes on the Supreme Court behind closed doors, leaning on a Northern justice to cave. And it worked. Grier caved and joined Taney. Which leads to this incredibly chilling moment at Buchanan's inauguration on March 4th, 1857, just 2 days before the Dred Scott decision is officially released to the public.
We call this the inaugural tell. In his inaugural address, standing before the nation, Buchanan brings up the explosive issue of territorial slavery.
Right.
And he says, essentially, this is a judicial question which legitimately belongs to the Supreme Court of the United States, before whom it is now pending, and will, it is understood, be speedily and finally settled.
Unbelievable.
And then he tells the public that whatever the court decides, he will cheerfully submit to it, and that all good citizens should do the exact same.
He is standing there, acting like he's waiting in suspense for the profound wisdom of the court, lecturing the public that they have to obey, when he already knows exactly what they're going to say because he helped engineer the ruling.
It was a highly coordinated piece of political theater designed to force the country to swallow a pro-slavery legal coup under the guise of respecting the rule of law.
Buchanan and Taney genuinely thought they were political geniuses. They thought they had engineered a masterstroke that would permanently end the slavery debate, marginalize the abolitionists, and save the Union on Southern terms. But when you look at the historical timeline, what actually happened when the public read this decision?
It was the ultimate catastrophic backfire. Instead of removing slavery from politics, the Dred Scott decision aggressively, violently nationalized it.
Because By ruling that Congress couldn't restrict slavery in the territories, Taney destroyed the very concept of compromise.
Exactly. For decades, the fragile Union had been held together by territorial compromises. You keep your side of the line, we keep ours.
Yeah.
But Taney's ruling essentially said that slavery is a constitutionally protected national right that supersedes any local or federal attempt to contain it. The immediate terrifying realization in the North was, if the Supreme Court can force slavery into free federal territories, what is stopping them from eventually forcing it into established free states?
The Northern reaction wasn't submission, it was seismic recoil.
The Northern press exploded. They called the decision a wicked and false judgment, a deliberate iniquity. Rather than settling the issue, it instantly handed the newly formed Republican Party, whose entire foundational platform was stopping the expansion of slavery, a massive, unifying rallying cry. It proved their worst fears were true.
And this is where a rising, relatively obscure politician from Illinois steps onto the national stage in a major way, Abraham Lincoln.
Lincoln recognized the danger of the Dred Scott decision immediately. He saw that it wasn't just a ruling on one family's case, it was a blueprint for the total nationalization of slavery. And it became the central, burning focus of his famous 1858 debates against Stephen Douglas for the Illinois Senate seat.
I really want to dive into the mechanics of Lincoln's argument here, because the dossier points out he had to thread a nearly impossible, dangerous political needle.
He did.
On one hand, he's a lawyer who deeply respects the rule of law and the institutions of government. On the other hand, he's facing a Supreme Court ruling he believes is morally repugnant and constitutionally fraudulent.
Oh.
How did he legally justify attacking the court without sounding like he was advocating for anarchy?
It was a brilliant, highly technical tightrope walk. Douglas, his opponent, argued for popular sovereignty, letting the territories vote on whether to allow slavery. But Dred Scott made popular sovereignty illegal because the territory couldn't ban property. Douglas tried to trap Lincoln by saying, "The Supreme Court has spoken, we must obey." By attacking the court, Lincoln is advocating for lawlessness and mob rule.
How does Lincoln counter that specific trap?
Lincoln made a crucial legal distinction between res judicata and stare decisis. He granted that court rulings must be obeyed in the specific case they are deciding. That's res judicata.
Okay, that makes sense.
He explicitly said he was not advocating for breaking Dred Scott out of jail or violently defying the court's order regarding that specific family.
He accepted the tragedy of the immediate outcome to maintain the rule of law.
Yes. However, he vehemently argued against accepting the ruling as stare decisis, as a binding national political precedent. He argued that because this specific ruling was based on demonstrably false history and corrupt partisan logic, it should not be accepted as a binding rule for the whole country's future.
He's saying, we accept the ruling for the Scots, tragically, but we absolutely refuse to accept this as a precedent that binds the legislative future of the United States.
Precisely. He pledged to work entirely within the political system to overturn the decision. He argued that the people, through their elected representatives, had the ultimate right and duty to oppose the court's political overreach by passing new laws, electing new presidents, and appointing better judges.
Let's look at the mechanics of what happens next. If we connect this to the bigger picture, this single, arrogant legal decision acted as a massive accelerant. It polarized the electorate so severely that it essentially carried Lincoln to the White House in the election of 1860.
The fallout from Dred Scott completely fractured the Democratic Party. It split them into Northern and Southern factions, which allowed Lincoln, running on a strictly anti-Dred Scott platform, to win the presidency without securing a single electoral vote from the South.
Wow.
And his election, driven largely by the massive Northern backlash to the court's ruling, was the direct, immediate trigger for Southern secession.
Chief Justice Taney tried to stop a crisis, and instead he dropped a match directly into a powder keg, dragging the country directly into the bloodiest conflict in its history. Which leads to a massive structural question. So what does this all mean for the Dred Scott precedent itself? Once the Civil War starts and eventually ends, how do you actually get rid of Supreme Court ruling that is this deeply foundational?
It's a sobering reality of the American legal system. The Dred Scott decision was so sweeping, so deeply embedded in a constitutional interpretation by the highest court in the land, that it couldn't just be slowly chipped away by later courts. It wasn't narrowed. It had to be buried.
And burying it required the trauma of a civil war and the literal physical rewriting of the United States Constitution.
That is the only way a Supreme Court decision of that magnitude dies. The political process had failed. The judicial process had spectacularly failed. It required a physical and constitutional remaking of the republic from the ground up.
Let's look at the mechanics of that remaking. The first step, obviously, was the military victory of the Union, followed by the passage of the 13th Amendment in 1865.
The 13th Amendment ended the institution of slavery entirely, fundamentally altering the economic and social foundation that Taney was trying so desperately to protect. But the 13th Amendment alone didn't solve the citizenship problem that Taney had created in his ruling.
Right, because abolishing slavery doesn't automatically grant citizenship. You could have a nation of free people who are still not legally citizens, especially with the Dred Scott precedent still technically sitting in the law book saying black people cannot be citizens.
Exactly. So in 1868, Congress passed and the states ratified the 14th Amendment. And if you read the opening line of the 14th Amendment today, it might just look like standard legal boilerplate. But when you know this history, you realize it is a direct, permanent legal assassination of Roger Taney's holding in Dred Scott.
I have the text right here. The opening line of the 14th Amendment reads, "All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside."
It is a total, permanent rebuke. Notice what it doesn't say. It doesn't mention race. It establishes the concept of birthright citizenship. By simply stating that anyone born on American soil is automatically a citizen, it permanently erased Taney's twisted originalist argument at the root.
That's powerful.
It took the immense power to define citizenship away from the Supreme Court and embedded it directly into the unalterable bedrock text of the Constitution.
It's an incredible lesson on the mechanics of power. It synthesizes this idea that some rulings, when they are so profoundly detached from justice and so completely destructive to the fabric of the nation, can only be overturned by the people acting collectively, rewriting the rules over the court's head.
It demonstrates that the Supreme Court, despite its immense power, is not the final, unassailable word on the American project. When the court fails completely, the sovereign power rests with the people to amend the Constitution. But we must never forget that the cost of the court's failure in this specific instance was 750,000 American lives.
As we wrap up this deep dive, I want to review the journey we've taken today. We started in the murky, complicated reality of the 1830s. We have to remember, Dred and Harriet Scott, not as legal footnotes, not as typographical errors in a textbook, but as parents. They were human beings who took monumental personal risks, throwing themselves against a terrifying, violent system for the sake of their daughter's freedom.
And we saw how their deeply personal, desperate fight was hijacked by a Supreme Court that completely abandoned its role as a neutral arbiter. The court attempted to play partisan politics, colluded in the shadows with the president-elect, and issued a maximalist ruling meant to permanently protect the institution of slavery.
And in doing so, they plunged the entire nation into war. Looking deeply at this, history isn't about scoring points. It's about observing the stark, objective reality of how institutions function and how they fail. It's a case study in what happens when the highest court in the land abandons neutrality, gives in to motivated reasoning, and tries to act as a supreme legislature.
It is a warning from history about the fragility of our institutions.
Which brings us back to where we started. We talked about that expectation of elevation, the comforting image of the court as a temple of neutral umpires just calling balls and strikes. But the reality is far more fragile.
It always has been.
The Supreme Court has neither an army to enforce its will, nor a treasury to buy compliance. Its entire power, its very existence, rests solely on the public's belief in its legitimacy. It only has power because we agree that it does. So it leaves you with this final thought to ponder. When the court steps out of its role as an umpire, takes off the mask, and attempts to unilaterally settle a massive moral and political crisis by pure fiat, does it actually resolve the issue for the country? Or does it merely destroy its own legitimacy in the eyes of the public? Think about that.